Hello, my name is Tanya Riles, and I'm the consultant for governance and management with the Vermont Department of Libraries. Thank you for utilizing this short trustee orientation video on open meeting law. Before we start, a disclaimer. I am not an attorney and I cannot provide you with legal advice. Every library should be in touch with its own counsel for legal advice about how to handle specific situations. This video is most applicable to municipal libraries, although it is also applicable to incorporated libraries wishing to meet Vermont public library standards and best practices. Open meeting law is intended to ensure that the public has an opportunity to participate in discussions of and decisions by their government. What constitutes a meeting? A meeting is any quorum of the trustees discussing library business. Time and location are not factors, and this is particularly important to remember when communicating with other trustees, including by email, text, chat, or phone calls. When it comes to meetings, there are several items that you and your library director must be mindful of. Please note that this is only a brief summary. First, a physical meeting location for public participation must be provided with at least one member of the public body, staff member, or designee physically present throughout the meeting. Advance public notice and agenda for meetings must be posted in 3 physical locations, including in or near the municipal office. Public comment should be allowed. Meeting minutes must be made available after 5 calendar days from the day of the meeting. Executive sessions have their own rules, which will be discussed in more detail later. There is a temporary suspension currently in place regarding open meetings. Beginning January 18th, 2022 through January 15th, 2023, public bodies may hold fully remote public meetings. Under this temporary suspension of normal open meeting laws, a physical meeting location is not required. At a remote meeting of a public body, the meeting must be recorded, use technology that permits public attendance, and allow access by telephone. Meeting agendas must be posted and include information that enables direct access and participation. Meeting notes must be posted not more than 10 business days from the day of the meeting. Returning to executive session, you may wonder how it fits with the intended purpose of open meeting law. There are specific and limited reasons trustees may enter into executive session. Entering executive session requires a majority vote of the board, and the motion must specify the nature of the business that will be discussed. The chair will ask the public to exit, and the board may invite staff, clerks, legal counsel, and persons whose information is needed to stay. Inside of the session, trustees may only discuss the specific business and cannot take a vote. Any motions and votes on the matter must be held upon returning to regular session. Please note that the information here is not a full and complete summary on open meeting law. There are additional stipulations you will want to be aware of for regular, special, and emergency meetings. Additionally, while not required, public bodies are encouraged to provide an avenue for remote public attendance and participation, post notices electronically, and record their meetings. Adding these elements will help make your meetings more accessible and transparent. Again, every municipality should be in touch with its own municipal council for legal advice about how to handle specific situations. Municipal libraries may also consult with the Vermont League of Cities and Towns. You may also want to confer with private legal counsel. Thank you for your attention to this and for your work to provide library services. On the screen are links for more information. My information is also on the screen, and you are welcome to contact me.